Hello, my name is Amy Foerster, and I'm a litigation partner with Pepper Hamilton. I want to welcome you to the next installment in a series of podcasts that Pepper Hamilton and Troutman Sanders are producing to discuss litigation topics that have been brought to the forefront by the COVID-19 pandemic and how businesses might be able to prepare and respond. Today's podcast is going to focus on the impact of the COVID-19 pandemic on litigation itself, both ongoing and newly filed cases. Our panel today includes Jeff Carr and Kessel, both litigation partners with Pepper Hamilton, and Alison and Lindsey Mann, litigation partners with Troutman Sanders. Each of our panelists has extensive experience representing clients in complex litigation matters in state and federal courts across the country, as well as before a broad spectrum of administrative agencies. Our panelists are going to be addressing current trends and tips to keep cases progressing, virtual depositions, issues to consider for when the courts reopen their physical operations, and impacts of the virtual work environment on data collection. We're also going to be forward-looking, considering some permanent changes that we might see to litigation practice following COVID-19. With that brief introduction, I'm going to dive right in. Let's start by discussing current trends we are seeing and how we can move cases forward in light of the current delays and stays. For that, I'm going to turn it over to Kessel.
In general, courts are closed throughout the country in varying degrees until at least June 1st of this year. And by varying degrees, I mean entirely closed for business, where the courts aren't even accepting filings, much less conducting hearings of any kind, telephonic or otherwise, to operating, with the exception of in-person proceedings, fairly normally, where they're accepting filings, ruling on motions, and conducting hearings both telephonically and through video conferencing. By way of example, I had 2 hearings last week in federal court, each of which were conducted telephonically, and they were significant matters, and they went off without a hitch. Conversely, in the Orange County State Courts, they're not even accepting filings, and they will not, and the filings won't even be processed until the courts reopen sometime later this year. The effects and a lot more in common, and fortunately so. First, a tremendous backlog that has been developing. Again, using California and Orange County in specific as an example, by the presiding judge that there are approximately 24,000 cases that need to be rescheduled on the criminal calendar, 6,000 of which are felony cases. On the civil calendar, there are 9,500 hearings that are required to be rescheduled, and 25,000 new civil case filings, which have been submitted but will not be processed until the court reopens. And the ramifications of that backlog are multifold. Civil judges are going to be enlisted to help with the criminal cases, consistent with criminal defendants' constitutional rights to speedy trial. And as a result, the earliest that civil motions are expected to be heard at this point are late July or August at the earliest. And the delay, like I said, will also be exacerbated by the fact that the filings that have come off, the 25,000 new cases in Orange County that have just been filed, will not even be processed until the court reopens, which again at the earliest looks like June 1st. I want to point out that, as the pandemic and its effects continually evolve, so do the court's responses to it. And I would suggest or point to at least 2 websites where I found a survey on both a national and a very specific state level. On a national basis, both at federal and state courts, I looked at my alma mater's website, and the NYU Brennan Center for Justice does a great survey that's updated very frequently with respect to how courts across the country are dealing with the effects of the pandemic. The state courts in California also have a website and have a matrix where they go through what is happening in each of the 58 counties in the state and update that as well. The the anticipated changes in practice that I believe are going to happen and I've seen are that motions are going to be decided on the pleadings. I believe in many cases, and without oral argument, unless specifically requested by the court. More akin to what you see many federal courts do and a lot of courts here in the Central District of California do. And I think that puts a large emphasis on the quality of the writing and getting to the point, because you're not going to have a chance to make up for what's not in your papers in oral argument. When hearings are held, I expect that you're going to have to be short, sweet, and get to the point quickly. And I expect that discovery and other similarly less substantive motions are going to not only be discouraged, but that the courts will take a dim view of them and, if necessary, farm them out either to judges pro tems or to private arbitrators. And so, the takeaway from that is that choose your battles carefully. Judges are going to be overworked, they're going to be stressed out, and they're only going to want to hear the matters that absolutely need to be heard. Next, no pun intended, I believe the jury is out, so to speak, as to when and how jury and bench trials will resume. By way of example, in Orange County, remote depots are now not presently required. And if the parties are subsequently not ready for trial, the court has made clear, at least the presiding judge has, that a trial date will not be set. And if a practitioner can't be forced to personally attend a deposition, which is understandable if, for example, he's in the he's older, or he or she is older, and therefore target group. I think the same will apply. I expect the same to apply with respect to trials, both in terms of for practitioners and in terms of impaneling a jury. And I think we're going to have some very interesting questions in how to properly balance the administration of justice with public health and safety concerns and what liabilities may result from it. I have seen some cases settled or dismissed due to the reassessment of client priorities, cash flow, whether or not the ends justify the means, types of analyses, and also to maintain relationships that parties believe are going to be essential to their future business operations. And then finally, while hearings, trial, motions, and other court proceedings each have been adversely affected in varying degrees, discovery has largely gone on unabated and without any real significant changes in attended deadlines. And so with that, I would turn back to Amy for discussion as to how we deal with discovery during this pandemic.
Thanks so much, Alan. I'm going to turn it over to Alison and ask Alison, can you please talk about how we can keep cases moving forward in light of these delays?
Absolutely. Thanks, Amy. To reiterate some of the points that Alan covered, discovery, for example, continues to move forward despite some of the setbacks in the hearings and trials. E-discovery is sort of the land that I occupy my days and nights, and in that space, we're continuing to collect client data remotely. That's technology that's been around that we use all the time, but it's become even more important while we're all in isolation and remote. In addition to remote data collection, we're, of course, processing and analyzing client data in cloud-based applications and conducting virtual document reviews, adding additional layers of security that we might not have had when we were doing document reviews on premise in the law firm to make sure that the reviewers have limited access and the inability to download documents to their machines and things of that nature. So on the discovery front, certainly able to do electronic discovery virtually and pretty seamlessly. There's additional considerations in terms of data security and logistics, and as we're all experiencing, in some instances, needing to help our clients and colleagues navigate new technology challenges. But it's been one area of litigation where we've seen a lot of consistency and very little delays.
Thank you, Alison. That's a great segue to our next topic, which is one we've been getting a lot of questions about: Lindsey, can I ask you to please talk a bit about the challenges and practical considerations of virtual deposition?
Thanks, Amy. Yeah, it is an interesting topic, and you're right that we're getting a lot of questions about virtual depositions and how to go about them. It's a big topic, so I'm just going to highlight a few areas where we've had the most questions, starting with technology. So, a lot of our vendors that we use routinely have been reaching out to us, and they are working on virtual deposition platforms that make it easier to take depositions in this remote work environment. Alison and I have actually participated in a couple of them, and they're really interesting. I encourage you, if you're thinking about taking a deposition in a virtual environment, to participate in a demo if you can, or talk to someone who's seen it, because the layouts and platforms are maybe a little bit hard to get used to. There are some things you'll have to consider if you're going to go that route, like, for example, whether to preload your exhibits or not. I mean, the softwares we've seen have a layout where you can preload them and share them when you're ready. You'll also need to consider, for example, how many video feeds you need. Do you want just the witness on the video? Would you like for the questioning attorney to be seen, the defending attorney? So those are considerations to think about before you, or as you're engaging your virtual deposition vendor. You'll also, another thing that I think is interesting is thinking about a way in which you could be assisted in taking a deposition by a second chair attorney, paralegal. If someone's going to be helping you upload exhibits, you'll have to make sure they have access to be able to do that. And also think about how you might communicate with them. If you're using your phone audio to take the deposition, which is what most of these vendors recommend, you'll have to come up with some alternative way to communicate with your assistant, for example, through Skype maybe, or email. But those are kinks to be worked out in advance of the deposition for sure. Another thing I wanted to touch on was exhibits. And we've gotten a lot of questions about exhibits and whether it makes sense to preload them into the virtual platform, or whether you should go an analog route and print them out and send them by US mail or FedEx to the witness, to opposing counsel, to the court reporter. I think there are pros and cons with both methods. I think if you can upload them to the virtual platform, you have a lot of flexibility in order of depositions. You don't have to pre-mark them all. You can, it's almost like having a stack of papers at your side in a normal deposition, and you can share them when you're ready. It also captures edits made during the deposition very easily, so you can see the witness marking a document, and that would be captured. It keeps people from reviewing the documents ahead of time. One downside is that it may be difficult to flip through a large PDF, for example, electronically, and some people are just more comfortable holding a piece of paper, especially if all they're working with is a laptop screen. So there are pros and cons to each. I will say, if you decide to go the traditional route and print the documents and send them by mail, you should put them in a sealed package and instruct the witness not to open them, and instruct the lawyer, opposing counsel, not to open them until you are on the record. Alison and I have been working on a sort of interesting paper about the ethical considerations of practicing law in a remote world, and that's one topic that keeps coming up. So if you were to receive exhibits through the mail, are you allowed to look at them? Could you talk to your witness about them? I think the answers to those questions are likely no, but to protect yourself as best you can, just send a note instructing them not to open the documents until you're on the record. Speaking of instructions, I wanted to say, also when you go on the record, I think it'd be helpful to say, okay, now open your envelope, and so that's all captured on the record. You might also instruct them to get rid of other technology, get rid of their cell phones, Kindles, whatever, anything else that they might be using to communicate. You don't want to think that opposing counsel is suggesting answers or doing anything like that, but just to protect yourself, you want to try to get rid of all of those distractions. I'll wind this down. Another thing that most of this conversation has been focused on tips for taking a deposition, but I think defending a deposition also presents some interesting challenges virtually, and I think highlights a really critical need to have a detailed prep session, or maybe two. Talk through the importance of allowing time for an objection. That's something we do typically anyway, is ask our witness to pause and think about the question before they answer. I think it's critical in this virtual environment to allow the defending attorney to raise an objection if there is one. And then, just develop some sort of system for conferring with your witness during breaks. Again, you might have that same challenge with the phone audio, so just come up with a way that you can communicate with your witness during breaks.
Thanks, Lindsey. What can we do if folks are ready to move into the virtual world? And I think Lindsey hit on much of that, but things we can do are, we can help develop an internal toolkit so that attorneys are prepared to tackle these virtual depositions, taking into consideration all the really important points that Lindsey already raised. And also working closely with those court reporters and videographers with whom we have tight relationships to make sure we can make this happen as seamless as possible. We have offices across the country, and we are certainly happy to work with folks and help make those spaces available to the extent possible. But with that, let's turn our attention to what's going to happen when the courts are fully open for business. I'm going to turn to you, Jeff. What types of litigation issues do you see increasing or crowding the docket at this time?
Thanks, Amy. It's hard to imagine what's not going to be around the corner. I think we should be more inclusive as to what we talk about, what we're going to see, because the amount of disruption in business, the economy, and life in general, it's hard to imagine area law that would be insulated from the pandemic. And I see many areas of litigation perhaps increasing. The obvious ones are insurance coverage litigation. We've already seen dozens of cases filed throughout the country. In fact, there was an application made to the JPML on Monday for an MDL to be in the Eastern District of Pennsylvania. There are also states, at least a half dozen the last I looked, that are considering legislation that would clarify that COVID-19 constitutes property damage or physical damage, and therefore the insurance industry is likely to be pushing back, and that will be another area of litigation. Another obvious one is bankruptcy litigation. As much money as the government can throw at small business and medium-sized businesses, I think there's going to be a lot of bankruptcy issues. And I call those two, the insurance issues and the bankruptcy issues, kind of the obvious ones. The not so obvious ones are your contract cases. The massive disruption in the markets, there are going to be contracts that are bound to be breached, and they're going to be breached early, and they're going to be breached often. And I think the sky's really the limit on contract cases. I don't think there's any particular area. For example, purchase orders are not going to be filled. There's going to be late or non-delivery of products. Supply agreements might be affected because of this disruption in the supply chain. For example, raw materials sourced internationally. There's a couple issues there. You have the world in shutdown, not being able to ship because of government restrictions. And you also have worker shortages in different locations. So even if you didn't have government restrictions, you have the inability to staff in order to fulfill orders. Also, simple breaches for failure to pay. Right now, cash flow is difficult for many businesses, and they have to prioritize what are they going to pay, and they're going to have to selectively breach contracts. There's real estate lease litigation. There's been a lot of talk about having even big box retailers stop paying landlords. And on the flip side, landlords may not be able to meet construction or delivery obligations under leases. So the one thing that I can say is that I see a lot of litigation. I don't think it's limited to any particular area as it relates to breach of contract, but perhaps we should be looking at standstill agreements so cooler heads can prevail. The other major area I see is consumer cases. The travel hospitality industry is going to be hit for refunds or change fees that are imposed. Ticket sellers for sports entertainment for canceled events. Major League Baseball was sued, I think, today or yesterday, and all the online ticket sellers were sued along with all the Major League Baseball teams, I think, in California by a class action alleging that the games weren't merely postponed, but rather they were canceled and they want their money back. Everyday things, gym membership refunds, other memberships where the businesses were non-essential and shut down. You're going to see litigation there. And we've already seen some price gouging litigation against Amazon for things like toilet paper and hand sanitizer. So I think there's a lot of consumer cases. I think there's a lot of commercial contract cases. And finally, there's going to be, employment cases. There's many layoffs. I'm sure there's WARN Act issues. When there are layoffs, there tend to be more discrimination issues. Perhaps whistleblower allegations. We have employers now that do not know what the new normal is. They may not be following the CDC guidelines or OSHA guidelines or not follow them carefully enough. Could be wrongful death. I know Walmart was sued for wrongful death, and while we have the workers' comp bar, perhaps there's going to be litigation regarding how that workers' comp bar is going to hold up in light of CDC guidelines and intentional acts or OSHA guidelines and failure to follow. And even non-compete cases may arise. You're going to have a lot of people unemployed like you do now, and when they flood back into, hopefully, the workplace, they might be landing at competitors. So there might be non-compete issues and also trade secret issues. So like I said before, I think there's really very few limits I see on future litigation. It's just a lot of uncertainty as to the volume, but not uncertainty as to the breadth.
It sure sounds like there's going to be some backlog necessarily when the courts open their physical locations. Are there any things you can think of that attorneys can do now to help manage that backlog in the future?
Managing backlog is going to be incredibly difficult, not only for the lawyers and the parties, but also the courts. There was a non-scientific poll by the National Judicial College, I think earlier this week, and to give you an example of the extent of the backlog, that non-scientific poll determined that courts were down to operating at 25% or less of their normal operations. And that was a poll of federal judges from around the country, approximately 800 plus judges responding to that. So the backlog is going to be significant. Courts have pushed deadlines, as Alan addressed earlier. We have extended judicial holidays, for example, in New Jersey to try to manage that backlog. As Lindsey, I believe, discussed earlier, jury trials are going to be different, or Alan discussed, jury trials are next to impossible, if not impossible, especially in civil litigation because of the shutdown of the courts and there being no one physically at the court or permitted in the courthouses. So we could pivot and see a lot more bench trials, for example. We may see, and we're starting to see now, at least I am, that the court is attempting to manage its docket and the backlog by, as Alan mentioned, having more motions heard on the papers, which is common in our federal court in New Jersey, but not common in state court. But the state court is also moving to Zoom or Microsoft Teams conferences and arguing motions. It's not as efficient as being in person, but they are attempting to manage the backlog that way. And as long as the attorneys embrace the technology and assist the court in working remotely and working virtually, that should ease some of the pressure on the backlog that we're seeing.
Thank you, Jeff. Lindsey, what other ideas should we consider in terms of steps that we can take now to help avoid backlog or gain a strategic advantage once the courts are fully open?
Amy, yeah, one thing that I've been thinking about a lot is moving into more virtual arbitrations and trying to have some disputes that don't require jury trials resolved through arbitration, for example. I do a lot of consumer class litigation that Jeff was mentioning earlier, and a lot of that is already, as a result of the strong enforceability of class action waivers, is generally going to arbitration anyway. And so if you are a consumer-facing industry and you don't currently have a class waiver provision in your arbitration agreement, you should certainly consider it. But just more generally speaking about arbitration, I think, as you all may know, it is a matter of contract. It's a matter of agreement. And so as you're thinking about your new agreements, or if you want to go back and take a look at the agreements you currently have in place, you might take a look at an arbitration provision and consider adding one if you don't have one. You might consider amending one if there's one already there, for example, to make arbitration mandatory, or to include rules on virtual arbitration, or even to be more specific about the administrator. If you come across an administrator who's doing a great job at managing virtual arbitrations, maybe you want to change your administrator to reflect that. While you have your contracts out, you might as well take a look at some of the other provisions too. I think indemnification is a big one I would take a look at. I also think force majeure provisions are going to be critical. We have a whole other podcast on that, so I recommend that one to you if you're interested in it. And then I guess I'll just plug at the end here some contract analytics that we do. So if you have a lot of contracts and you're looking to sort of analyze them all at once, we have contract analytic tools that can pull out all force majeure provisions, for example. So I just encourage you to take a look at the agreements you have in place, and then as you enter into new agreements, to think about the changes that you might need to make in light of the current pandemic.
Thank you, Lindsey. Well, with the 5 of us working in 5 different remote environments right now as a result of COVID-19, I'm going to turn to Alison and ask her to talk about how the remote work environment will impact data preservation and accumulation issues.
Thanks, Amy. We're definitely all living the dream of using, in some cases, very new technology, and in other cases, technology that's been around a very long time, but we've never been forced to use it to its full capacity. So we're definitely seeing a lot of data being generated in new locations. So for example, I can see people storing information locally when they may not have done that whenever they were able to come into the office, which can create some preservation and collection challenges, not insurmountable, but another location to look for data. All of this video conferencing can be easily recorded. A lot of our clients have sped up their adoption of some technologies that they might have normally put through more hoops and spent more time developing policies around so that they could quickly start using them. For example, Microsoft Teams and other collaboration tools. And they're having to pretty quickly make decisions about whether or not they're going to preserve those meetings and conferences and create, again, additional data sources. So these can be challenging sources in order to search and review, right? It's not a traditional document. It's a video file, and it could be a large file, and it could be a cumbersome file. So we're definitely generating new sources of information. And we're, as a decentralized workforce, there's a higher risk of data being created on mobile devices, text messages, and I think even just on this call today, I'm using Skype, my mobile device, Blue Jeans video conferencing, and my network connection. So we're all of our clients and all the lawyers out there are definitely being asked to use new sources of technology, and that can create some interesting challenges. So just thinking about making sure as we move forward, litigation that would involve data created during this time, being thoughtful and creative about whether or not there would be some new sources that would need to be preserved, possibly modifying your communications and your legal holds, maybe sending out reminders. This is a great time to maybe refresh your legal hold reminders and remind people of their obligations to preserve information. In many cases, those notices also direct users maybe where not to store information or where not to create a source that's hard to preserve and collect. So this could be an opportunity to remind people about appropriate use policies and procedures and where you should not be storing business-related information so that you're not creating little hidden troves of fun e-discovery surprises for later. The last thing I would say on that kind of new sources of information is I suspect that requesting parties are adding this very quickly to their list of things that they're going to start asking for. It's not typically a source of information people seek in litigation, but now that we've all been creating all this great content and these podcasts and recording, I could see this being something people start to ask about whenever they're seeking discovery. So just thinking about that as you develop preservation plans and litigation response plans, how you're going to manage that and understand those issues so that you're not having to be reactive to them on the fly.
Thanks, Alison. Jeff, in-house counsel are already under all sorts of new forms of strain as they work to serve their in-house clients remotely. But what can they do to address these particular issues with regard to the remote work environment?
Yeah, this is another pain point for our clients who are already in a very stressful situation. And I'm blessed to work with some very capable in-house counsel. And I say that in all respects, but especially as it relates to electronic discovery and understanding their company's IT structure and where their data resides. many years ago was, when this whole e-discovery process started, I probably couldn't say that, but in this day and age, clients and counsel, in-house counsel, are very good at knowing where the data resides, having a point person within their IT department to identify the data and to hold the data and preserve the data. The problem, and Alison pointed it out, and she's the expert in this area, I'm just a litigator who addresses these issues on an as-need basis. The problem that I see is that in-house counsel now has to learn this all over again because the data is changing, the manner in which people are storing information is changing, the likelihood, like Alison said, that things are going to be saved on a remote device presents challenges. And how we define what we preserve is going to change too. I can tell you many clients would view instant messaging as not being something that needs to or should be preserved. But in my practice alone, I'm using more IM now than I ever had in the past, and I'd imagine our clients are doing the same. So it's going to be relearning their data environment, how people are storing things, and making sure that they are enforcing whatever rules or new rules they're going to impose to make sure that they don't see this issue come back to hit them in a future litigation, because that's what this is about. It's about future litigation and whether our clients were adept enough in moving to preserve documents in the litigation.
Thank you, Jeff. To close out today's podcast, I've asked each of our presenters to look ahead and think of a way that this pandemic might permanently change how we manage our litigation files, or more broadly, how we're working together. So I'll start by asking Alan.
The question I thought of was, will courts, clients, and lawyers be more or less willing to engage in virtual hearings, arbitrations, depositions, etc.? And I think the answer to that is yes, and I also think it's increasingly so as the effects of the pandemic continue on the practice of law, and as each of those various parties become more accustomed to and comfortable with the continually evolving and impressive technology through trial and error. I can say that while I was initially adverse to it, I recently had a television interview, and some of the capabilities that others on this panel were talking about, and Alison, really were remarkable to me, and it was as if I were there. So if somebody like me can change and become more accustomed to it, I'm sure there's hope for others.
Jeff, what are your thoughts?
These times are abnormal, but I think when we're on the other side of this, what we view as being abnormal now will be more normal. Courts are embracing technology. I see the courts having more virtual hearings, more Zoom or Skype conferences. In New Jersey, we're so densely populated, and we have courts on every corner that getting to a court is not an issue under normal times. In other jurisdictions like Wyoming, they've been probably doing this longer and are more comfortable, ironically enough, using technology because they don't have access to the courts that we have here. So I think the courts are going to embrace technology. I think you're going to see less travel, and I'm seeing it now, not only with the courts, but with clients and with my colleagues at Pepper and Troutman.
Lindsey?
Yeah, thanks, Amy. This has been a fun thought exercise. I agree with everything that's been said. I also think that firms and courts and clients are going to have to invest more in technology. I think we already see that happening. I think now that we've made this initial investment, I think that will continue. I think there may be some initial backlash, and we may have some people really resisting the move to technology. But over time, I think we are going to become more reliant on technology and less reliant on, for example, our office space. We already have clients who've moved into an environment where lawyers don't have offices, which seems crazy, but I think that that's where this is headed.
And what are your thoughts, Alison?
Thanks, Amy. I think we're definitely seeing something that really had started before we were all working so remotely, which is just the generation of so many different types of data, including when you think about the deposition technology. That's a great example of, in addition to recording the witness and the lawyer asking the questions, that technology can also record how the witness is interacting with the exhibit, how much time they're spending, what they're looking at, their clicks. So there's a lot of information that we're generating and tracking, including all these conference calls and video chats. And I expect there will be an increased interest in requiring folks to preserve, collect, and produce all the great content that we're creating. So a new thing to consider, not necessarily a new issue, but just evolving and new uses of technology.
Thank you, Alison. I'm happy that we're ending today's discussion by looking forward to a time when we are no longer under a state of emergency having such a significant impact on the courts and on our litigation practices. Thank you to Jeff, Alan, Alison, and Lindsey for your thoughtful insight. And thank you to those listening to today's podcast. If you have further questions, please feel free to contact any one of us or visit our joint Pepper Hamilton Troutman Sanders COVID-19 Resource Center at covid19.pepperlaw.com.